so that the recording makes some sense, we're waiting on folks to all come into the Zoom room, and we'll start in about a minute here.
I get to do this again this evening. What fun. I teach at Mercer this semester, so it's transactional IP stuff. So half of it in Zoom and half of it there. So crazy.
All right, I think I see most people have rolled in here. We're glad to have you all. Well, no, there's still a few connecting. Let me just give it a little bit longer. Okay, we'll go ahead and get started. Good afternoon, everybody. My name is Josh Curry. I'm a partner and the IP Group Vice Chair at Lewis Brisbois, co-chair of the Patent Committee, along with my colleague, Andrew Strickland. Thanks for coming to our CLE today. Before we get to the CLE that Keen DeCarlo is going to moderate, which looks like an exciting topic, I wanted to make one brief announcement. So we're always looking for more people to get involved with the Georgia Bar Patent Committee. If you're not sure what the Georgia Bar Patent Committee does, by coming to these CLEs, you know a big part of what we do. A large part of what we do is education for the section. So we typically plan and host about 3 or 4 CLEs a year. They're focused on patent topics. It can be any patent topic, litigation, transactional, commercial, foreign, whatever you would be interested in. We also plan some social events back when we used to be allowed to get together in person. We've done very limited number of those with the pandemic, but we have done some Zoom happy hours and stuff like that. And then we have a lot of flexibility to plan something else. So every once in a while, somebody knows a judge at the PTAB or the district court or federal circuit or whatever, or a good foreign speaker or another good speaker, and we can have those people come in too. So we'd love to have you involved. You know, if it's your first time on the committee, we don't throw you right into asking you to do a CLE right away. There are, probably 10 to 20 people on the committee from time to time. But if you're interested in getting involved, please reach out to me. My email address is on the screen, josh.curry@lewisbrisbois.com, or my co-chair, Andrew Strickland, his email address is on the screen as well. We'd love to have you or to answer any questions you have about getting involved. And one thing for folks at firms, this is a good place to send your mid to senior level associates as well. It's a great training opportunity for them. They can put together a CLE. So if you don't have time yourself at your firm, please feel free to conscript one of your juniors and ask them to participate with us. Several people have gotten good experience that way. So with that, I will turn the presentation over to Keen DeCarlo from Womble, who is going to be presenting on Assignor Estoppel.
Thanks, Josh. Much appreciated for the introduction. And again, I follow up, encourage involvement in this section. I think especially for the mid and junior level associates, a great way of getting better experience and quite frankly, creating a little bit more of a network. Keen DeCarlo, been practicing for a few decades here. Been teaching for a few decades as well in this space, and I'll be heading up the discussion on the Assignor Estoppel, and I'll let V introduce himself.
Hi, my name is Savasha Spadacharia, but I go by V, as Keen just mentioned. I'm a senior product counsel at Pure Storage. I'm actually remote in Texas, in Austin, but I've been in the being the patent practitioner for over 20 years, and currently handling IP, open source, privacy, all sorts of product related issues, regulatory and legal, and happy to be here today.
Excellent. So if I've got the slide deck up for everyone to take a look at, and it's been transported to it, feel free to use that. As there's more material in that slide deck than we'll be able to cover today, since we only have an hour on it, but I wanted to give you some background material that you could potentially reference on this. The strange part is that you look at this, most people, quite frankly, a lot of in-house, certainly a lot of patent practitioners wouldn't even recognize there's such a thing as Assignor Estoppel on it. We're going to talk about what Assignor Estoppel is, what Minerva held in that, and then potential implications for companies as they move forward in this kind of post Minerva world. Ultimately, here, the issue in Minerva resulted around, can a defendant in themselves in a patent action who's made an assignment, can they in fact later on challenge the validity of it? And we're going to talk about history on that, et cetera, as we move forward. Hold on, see if we can get this thing to cooperate with me. So context, historical for Assignor Estoppel. Think of it as an equitable doctrine that was brought up that effectively said, I'm an inventor. I'm assigning my invention to a company. By doing that, I'm changing the assignment was a transfer of ownership of that invention to the company, okay? The equitable doctrine that the Federal Circuit had adopted way back in the 1880s was, in effect, that person, that inventor, or anybody in privity with that inventor could not subsequently then challenge the validity of a patent that issued on that assigned invention. Basically trying to keep them from almost literally double dipping on it and saying, no, what I did in the past, that's worthless. What we're doing now is fine. I can challenge the validity. So that was a classic case in there, that kind of quid pro quo that was associated with this kind of equitable doctrine. Again, adopted by the Federal Circuit since 1880. And let's face it, anybody who's been practicing in this field for a long time has done assignments, continued to do assignments in this space. Okay, you do it routinely. Okay, files an application, you have them file an assignment with the company or whatever, transfer ownership of that. Okay, and we're going to talk about some of the now potential issues associated with that, just common everyday practice associated with it. Yes.
We're not seeing your presentation. Could you do the screen sharing again, please?
I will do that again. Hold on. Let me get to that. If it'll cooperate. Here we go. Everybody got it now?
No, we're not seeing anything.
Well, that's.
Oh, hold on. Now we are. Perfect.
Oh, yay. Party on. Here you go. Okay. So, bottom line is, we're in this kind of classic, the scenario that was from the 1880s is this kind of classic scenario. And then Minerva came into play. And when Minerva did its lovely actions here, hold on, they actually now address this issue, okay? Supreme Court had never prior to Minerva actually directly addressed that. Back in 1924, there was a case in which they implicitly approved of the doctrine, but have never actually expressed and had a holding that Minerva is what we want to do and how we want to do it. I want to actually kind of go over some of the background of Minerva so you can understand where this came up on it. So basically, we had a gentleman who came up with an ablation kind of technology. They filed a patent application on it. He assigned that patent application to the parent company in which he was employed. And that was the standard one where any kind of continuation application thereafter, developments after, were also assigned. So that kind of a blanket old form assignment that we're used to doing to his parent company, Novocept. Okay. Subsequently, the company sold that to it. They went through a chain of titles on that. Ultimately, the inventor himself left the company, went to found another company, Minerva. They developed a new technology that used thermal energy rather than radio frequency energy, which was kind of a, if you think, a relatively simple transition there to perform those intermediate ablations that they were doing in that space. Ultimately, Hologic then sued Minerva saying, you're infringing, okay? And what Takeda and Minerva wanted to be able to do is challenge the validity of those patents, okay? In this particular instance, okay, what had happened is post him exiting the company and its acquisition then by a subsequent company, that firm had filed for broader claims, typical kind of patent prosecution, when they found out that, oh, there's a path here for patentability that allows us to get broader claims. They pursued those broader claims and had a patent issued on those broader claims. Okay, that was post Trichetti's employment though with the company. Okay, so you can see originally he signed something with a certain scope. Subsequently, the company that acquired the technology expanded the scope of those claims and achieved a patent on it. And Minerva wanted to basically be able to challenge the validity of those patents or any of the patents in the family. And that's what the Supreme Court heard. Okay. So if you ever want to bore yourself silly listening to the judges at the Supreme Court argue over this, you're more than welcome to. It's actually some entertaining chatting on this. But the decision came down, but it was a 5-4 decision on this, not so it was a very close decision on whether or not to totally abrogate or eliminate Assignor estoppel, or subsequently what actually the majority came up with was to uphold the doctrine of Assignor estoppel, but with limitations. Okay, and those limitations we'll be describing on that. They looked at it in Equitable Doctrine and said, okay, we're going to make some changes here that secure those interests of assignees on that. Realize one of the things that that was discussed in court is the court was actually worried to a degree that since the 1880s, think of all the companies that are out there that have secured particular rights in that assignment and the transfer of ownership rights through those assignments to technology, with an understanding that I don't have to worry about a validity challenge from an inventor because of this doctrine. So literally since 1880s, we've been doing this. People, the Supreme Court, there was some fear expressed that if you totally abrogated that, the ability to, the doctrine of Assignor estoppel, that there may be some subsequent blowback in the marketplace, and they're trying to find a way. I think ultimately the court trying to balance, let's keep this, but let's strengthen it or provide some limitations relative to expectations of the parties when the assignment was transferred. Okay, so looking at this, you'll note that they felt just the blanket Assignor estoppel was a little bit too broad. It should not act as a total blanket ban on inventors or those in privity with them to challenge or conduct invalidity challenges on there. So they tried to suggest modes and methods in which to do that. And they come up with 3 potential limitations associated with that. Okay. And that's buttressed off of, on this slide, you'll note, you're very familiar with it. The inventor signs this oath that their original, here's the claimed invention. There's this candor duty about what they're doing. Okay. The court recognized that there would potentially be some contradictions between an inventor's position and their oath when they submit that. So all this is kind of going back to these kind of, what were the expectation of the inventor at the time of assignment, okay? They were trying to avoid any kind of inconsistency associated between what Assignor estoppel would stand for, but also preventing an inventor from potentially double dipping for all intents and purposes, with the thought that, hey, I can go here, I can make this thing, I can challenge the validity of that. Because let's face it, who knows the invention more than your inventors, right? They're into it. If they're going to be somebody potentially coming up with some damning invalidity arguments or some strange ones in that aspect, it's probably your inventor. But they're, again, trying to address all the issues associated with it to avoid this kind of inconsistency that results from them being an inventor potentially being able to assert that estoppel defense and being able to double dip on the profit sense. Okay. As I alluded to before, the court provided 3 examples in here about when an assigner potentially has an invalidity defense. Okay, we're going to talk about these in more detail in the upcoming slides. But the first one involves whether when an employee in, say, your standard employment agreement actually assigns their employment rights to future inventions before they can make a warranty of validity as to specific claims. We're going to talk about what that means for us and ways we can get around that as we move forward in the future. Okay, subsequent is when a potential later legal development renders irrelevant whatever assigner's warranty of validity was made at the time of assignment. And third, and finally, and probably the one, certainly the one that was most present in the Minerva case, but on a day-to-day basis is probably more prevalent, is when the patent claims themselves change after assignment and render then irrelevant the assigner's invalidity warranty at the point or when they sign that assignment document. But guys, if you have any questions as we move forward here, don't hesitate to throw it. I don't believe anybody's on mute, so feel free as we move forward onto this. Okay, going back. So the first one again, the employment agreement type agreement. So this kind of global overreaching, you're an employee, so that kind of employer-employee relationship where you're basically saying, if you're inventing, as you're hired to invent, and as a condition of your employment, you are obligated to assign those typical kind of employment agreements that read in that context, okay? Realize what you're doing at that point is saying, you're hired to invent, therefore you're obligated to assign. An invention hasn't occurred yet, right? No one knows what the invention is at that point, okay? So nothing in that then speaks to what the potential scope of those claims are that the person is assigning. That becomes problematic here. There's ways to cure that, and we're going to talk about that at the end of this presentation, kind of ways we move forward. But you can see this is a potential problem because oftentimes employers depend on this. They just look at it and say, no, they're under an obligation to assign. Yeah, they're under an obligation to assign, but then there needs to be next steps associated with that to ensure that they're actually assigning the particular invention to your company. Okay, let's see, sure. Second one, change in law. Okay, this is a little bit more limited context, but what you think about what the court was trying to do here is you've made a representation or you've made kind of an assignment in that context, but then the law changes. What is patentable, what is not patentable, whatnot. If the law changes in that context, the inventor could not have intended to warranty or do any kind of estoppel associated with that at the time that they executed the assignment document, because they were doing it as the law existed at that time, not as a change to move forward. Okay, I want you to think about this in context. Say you have an invention that potentially could also have software issues associated with them. We can practicing this can appreciate the potential one-on-one issues that exist around the minefield associated with that now in terms of patent. So maybe the thought processes at the point of assignment was not to pursue kind of software type protections at that point. Okay, magically we potentially then could say there are law changes which allowed Section 101 gets modified to such a degree that you could potentially get software claims to allow on there. That would be one where this exemplary limitation that the Supreme Court would apply to that, because the inventor at the time they assigned it would not have intended that you would have software claims that could potentially issue in that place. Okay, again, where the assigner at that point would not be barred to challenge validity. Third and final, and again, the one that was most present in Minerva, because there was broadened claims at the end of that, is when the claims that are at issue are materially broader than the claims that were assigned. Okay, so think about it. Some post-assignment development, a change in patent claims and whatnot, potentially the court is saying that can remove the rationale for applying Assignor estoppel. Okay, how many times in our practice do we potentially file an invention? Say you filed for an invention with a medium complexity scope of patent claims. Okay, you're trying to you believe these are patentable, but you're also trying to minimize file wrapper potential issues moving forward, and you're trying to expedite movement of patent toward allowance. Okay, routine, there was assignment made on those claims. Okay, subsequently in the course of prosecution of the claim, your assignment, your inventor leaves the company. Okay, so they're no longer in the picture. They're not doing anything else with the company. They've moved on. They're one of the mobile workforce that we have and that are so prevalent in present day. Okay, subsequently, potentially you have patent issues, or you file a continuation, or you make a modification to the claims such that now they're broader than the claims were that were originally filed or were present when the invention was assigned. That's a scenario in which now this exemplary scenario that the Supreme Court outlined, in that here the assignee would not be barred from challenging the validity of the claims because they would not have anticipated, or they could not, the claims of scope were X. You've made him this. He's only assigned this. Therefore, anything that's out in this sphere that he can potentially use and challenge for validity. Okay, so you can see this happens all the time. Okay, companies run into this, practitioners run into this. This is this kind of a routine context. So it's something we need to work for, and how do we protect ourselves? What do we move forward in this space? Okay. Bottom line is in here, if there's no consistency in the position associated with the claims here, if they're not, these claims mirror what I assigned, okay, there's no estoppel issue. And again, I think this is arguably the most relevant limitation that's expressed in Minerva. The rest they're relatively straightforward workarounds. And one of them, it's potentially hard to work around. The second one, where change of law, trying to be predictive of that would drive one insane, especially in-house counsel with large patent portfolios. Okay. Want to go over some real quick things here, and then we'll move into how to that. And one of them is the court actually, people are very familiar. You're not familiar with Assignor estoppel, but most people are very familiar with licensee estoppel, okay, under Lear, and what challenges could be made on that. They made it very, very clear that licensee estoppel is different in context, right? Obviously, they looked at under Lear, court said, because the doctrine fails to serve basically fairness issues. So walk through that. What happened in licensee estoppel? The licensee originally prevented a patent licensee from contesting validity of patent the licensee was paid to use, flipped that and said, you can do that. Okay, the licensee makes no assertion of the patent validity when they purchase the right to use, right? That's a licensee. Okay, if the patent is invalid, they can do that. They can challenge that. Here, much different. Okay, context. Because they wanted licensees to have this important interest, because of what we have here with the privity of the parties on here, you don't have that same issue that's under Lear. So licensee estoppel got beat up. Assignor estoppel was upheld. Okay. The other thing to think about is the Federal Circuit has already appreciated, so there's a differential here, that Assignor estoppel does not apply to inter partes review proceeding. Presumably, they've at least identified inter partes, but that presumably also approaches to any kind of post-grant review process, okay? Because they're looking at any person who's not an owner, okay? On that would not necessarily be able to do that. However, there is a privity issue associated here, Okay, if in fact they find the parties are in privity with each other, here Minerva is the owner, CEO, president of the company. They're in effect going to say they are an owner of it. Okay. So they didn't, I want to just put these in here for you. They're going to really go over the thing. Bottom line is the Supreme Court left the context of privity alone in this. Okay. Bottom line, inventor may be constrained by using, from arguing invalidity due to Assignor Estoppel. Company may not be constrained from using that. However, if there's close privity between them, the relationship between that inventor and company, the more likely they're going to call them as being in privity, and they'd be again potentially Assignor Estoppel would apply. So if there's questions on that, let me know. That can be available after to discuss that. Okay. So let's talk a little bit about some of those post actions on them. And V, you feel free to pick up whatever you want in this kind of space. But these are some of the kind of post whatever actions that are kind of recommended on that. And I'll go over the first couple, and I'll let V pick up the next few slides. So this first one is basically talking about the employment time agreements, that whole kind of context where you're hired to invent. Therefore, as a condition of your employment, and we're paying you to work, you're obligated to assign. Okay. The strange part is you look at that and you say it's risky to just look at those, that kind of, and there's no challenge clause or anything in there to say you're covered on that. Okay. Bottom line is there's a transfer of that valuable consideration in that contract relationship because they're ongoing employment. Okay. There's typically no other specific consideration that's given for the transfer or any ownership rights thereafter. Okay. Okay. So bottom line is these kind of second or quick claim assignments that we normally file for each and every patent as we move forward potentially are problematic in that they typically are kind of these kind of rogue structures that relate back, but there's nothing that with any kind of specificity of what's going on there. Okay. So some of the things you get to think about in terms of those assignments is what are the terms and everything? What are everyone focused in on? What is the assignment meant to cover? Okay. You should have explicit terms in there that actually express what you're covering in there. We're going to also talk about some opportunities about here about providing specific consideration for what you're doing, how you're doing. And you know, you filed a patent application, you filed an assignment. Here's $100 for that. See, there's some specific consideration beyond employment. But you want to grab the next one?
If I can add something there, that's a great point about the consideration. You know, one of the things that you know, a lot of companies like to have inventor awards, or whether it's a bonus award as a cash award, or if it's swag or whatnot, having a framework in place where that is, you know, if you don't have a type of rewards program or award program for your patent department, or for your patent inventors, it might be a good way to not only close this potential gap regarding consideration, but also just, you know, raise morale and get your inventors and your engineers excited about the patent program. One other thing I wanted to mention, I thought was interesting, is, you know, a lot of the quick claim deeds that were that we file with each of the applications where we file an assignment. You know, one method that you can at least, I mean, if you're getting an Assignor Estoppel argument brought against you, one possible way of overcoming that is by showing it in a holistic way that the inventor knew what their obligations were. And of course, having those gaps covered in your employer-employee agreement, as well as the individual assignments, is obviously important, but there is other ways you can further solidify that. For instance, by having regular training with your inventors, where you're stating that when you're going to be presented with an oath or declaration, as well as an assignment, it is for those inventions that is being filed. So make sure you read those specs and those claims and understand, especially if they're a broadening continuation, to understand that is what you're applying, that you are assigning to. Same thing goes with the employer-employee agreement. When you're onboarding employees, even though it's a future inventions, you may state, just that, this, of course, you don't have any inventions that are that you've come up with now, but in the future you will. And if you do, then these terms apply, and that is in the employer-employee agreement. So just a couple ways to kind of help establish a totality of circumstances showing that Assignor estoppel from equitable perspective may not be a great argument for the other side, because they very well knew what they were giving up. Back to you.
So the interesting part about great expression there be is think about it in terms of knowledge. All of us are used to, the companies routinely use provisional applications. Most people include at least one claim in provisional application to preserve potential foreign rights, etc. There may be an opportunity as you're doing that in that provisional application, putting a very, very broad claim with a discussion with your inventor. What is the potential expansion of that? For example, in the Minerva case, Roger, you went from one type of ablation technology to another, radio frequency to another. So but it's probably close, right? A claim or a discussion with the inventor that you typically do and say, hey, can you expand this? Is there other potential ways we can do that? Would get you to draft a claim where maybe it's an ablation technique for, so now you haven't even qualified what the ablation methodology is. So you're expansive enough to actually cover that. The strange part is that can be,
that's a great point, Keith.
That could be used both in following the claims, or alternatively, when you actually, the assignment for that, the assignment document that you have the inventor say to that, instead of that being just that kind of routine block, you have a paragraph that describes, as a written description as to what that is. Robert, I'll get to you in just one moment here, but bottom line is you put that language in the assignment. So it's very clear they've assigned the breadth of that. Hold on, Robert. Trying to unmute you.
One thing also just to consider is just to expand on what Keen was saying is, when you're trying to figure out alternative embodiments or ways of broadening, not only putting that information in the application, but also even thinking further upstream when you're finalizing the invention disclosure. If you can show that the intended definition that was broadened was actually something that was considered in the invention disclosure phase, then there's very little wiggle room for the inventor to say that that's not what he came up with, or she came up with.
And the key there is documentation, right? So you don't want to be in a position where you're just going, well, we talked about this, and this is happening years in the past. So having some documentation where you talked about potential scope expansion. The good part is most people on this call are probably well-versed in actually having those discussions. To how do you broaden up? What else could this encompass? Robert, you had a question. I think you're on mute. There you go. How's that, Robert? You better? Nope.
How about now?
I got you now. Thank you, Robert.
So I went through your slide deck and I didn't really see where there was, like a copy of the assignment. It seems like the problem is that the particular assignment was geared toward this employment invention agreement, which really doesn't define the scope, like you said. And I would believe that the best way to avoid the problem would be to just record an assignment for each and every disclosure that they're filing, an original disclosure that they're filing, because the assignment that you record in the patent office is not about the claims per se. It's about the technology that's disclosed therein, and that disclosure is what supports the claims. So any invention that you can get out of that disclosure would be assigned by the assignee by the assignor to the assignee.
That's actually not true. And that's what Minerva, that's the danger of Minerva, right? Because Minerva actually looked at the claims. They didn't look at the scope of what was disclosed, okay? They're defining it by the claims. And that's why I throw it out, because Robert, you actually outlined what we practiced with for decades and what's been practiced since the 1880s was you assign the technology. That's gone. The company that acquired that, in Minerva's sense, thought they had the ability to, well, we can use it for this too. We can broaden this up and read a claim that covers. They don't care. They're looking at the snapshot time when they assigned it. They're looking at the claim.
So I'm kind of I'd like to know what the assignment was that was recorded.
It was, think about it, you look at it and you, I believe it was very much like what you typically do. Here's the technology, any continuation of CIPs, anything thereafter is covered. That's the standard one each assignment, okay?
Wow.
So
all I gotta say is wow.
Exactly, that's why we're having this conversation, because it's much more of think of the issues that we have now. Even it's saved, right? But they saved Assignor Estoppel. What happens now when you acquire a company? What's due diligence on that? It's not now, give me all the assignments so I know I own all this stuff. It's, holy crap, give me all the assignments, when was it assigned? What are the stated claims when it was assigned? Did they get broadened? Did it get narrowed? What happened, in this context?
That seems like really bad law to me.
Yeah, it makes a little bit of a nightmare. Like, give you an example. In the scenario you'd had, if your person was still there, you hadn't done this. You just is like, here's an assignment, okay? And you followed a certain level of claim scope, that moderate claim scope. You subsequently get broader claims to issue. Good practice internally would be going back to the inventor and say, here, file this assignment on these claims. So you cover.
I would even say take one step further. You may even want to not use, for when you do continuations. And I'm guilty of doing this too. You just reuse old oaths, declarations from the original case. One possible way to that could leave you exposed under this new law, because the assigner might say, well, my original patent claims A, B, and C, D, A, B, C, D. Now you're only saying it's A, B, and C, but you just took my old deck and filed it. I would have never signed off on that had I known that you were filing a claim for A, B, and C. So that does beg the question whether, like, for every continuation you have a new assignment signed and filed, you also have a new declaration filed. It's signed and filed for those continuations. That would help close that gap in that argument.
Certainly, at a minimum, you want to do if I file continuation CIP, whatnot. The good thing is the agreement, everything you did provides an obligation for them to assign, right? But now you actually have to sit there and kind of go, we're filing on this, see the claims, here, file another, sign your name here on this particular assignment associated with it, okay? But that actually starts begging another question on that specific consideration. Are you providing something other than just employment for that specific invention going on there? There's, again, things to follow in that space. But yeah, Robert, what you outlined was, and why we're having this conversation is, this is exact the question. It's not I'm assigning technology. They're just looking at the claims. Did the claims change? Did they get broader? If they got narrower, they don't care, right? But if it's broader, all of a sudden you start bringing in this third person. Again, why I think it's arguably the most relevant portion that came out of Minerva. Okay, it's a nightmare. It's not so much a nightmare. You just got to put in place policies and procedures to manage this on a day-to-day basis.
Right.
But think of that. We have a couple decades worth of patents that are still alive, right? That are affected by this, that have been signed, owned by companies or whatnot, or actually the scope of the assignment is potentially a question. So acquisitions and whatnot, due diligence now on that in terms of just checking assignments has become much more complicated. Okay. And you can appreciate, I mean, I don't know, I think we've got 140 some odd people watching this today. But how many of your other patent brethren don't have a clue about this? So they're not going to appreciate some of the in due diligence kind of questions. They're not going to appreciate some of the questions that are asked. What was the scope?
Thank you.
Why do you care? What do you want to know? Because it affects what we're doing.
Well, one of the issues also that where this can come up is if, Keen and I were talking before this presentation as to when is the highest likelihood of this happening? Well, this would probably be happening when you have an inventor who has left your company and went to a competitor or to a startup who then starts competing against your company. And you have this issue where you may have to come after them. One way to make sure that you are protecting yourself is getting the broadest claim on file with the patent office when you can. And again, having it in the disclosure also helps, helps solidify that. But that's always been the big issue with patents is you have to have an incredible amount of foresight as a patent practitioner to think about and envision where potential competing alternative embodiments might come into play. And are those covered in what you're claiming or you have the spec describing?
So having something on file provisional, whatever you found here, but because the Supreme Court's focus was on the claims themselves, not on the technology, having something in there where you go to the broadest possible claim, maybe some validity, or alternatively, and as shown up on the slide here, that second optional section, some broad-based claim have presented. If you don't file it, you've presented it to the inventor, and this is the scope of what we're talking about, the potential scope, expansion on that, and having that acknowledged by via these oaths, decks, or whatever you need to do, but have some kind of written documentation at the time that here's the scope of the invention that we're talking about. We may be following this in separate applications as we move forward in different aspects, but the scope of what we potentially want to file on covers this. So you actually have some documentation on that, at least internally, where you can potentially say that. So you can see in the due diligence, here's all the assignments that were done on it. Also, here's the background material in which the scope of everything that was covered under these assignments is covered. So you actually have that kind of documentation as you move forward.
And one issue I was just thinking about, Keen, that when we, if you have an acquisition, if you're acquiring another company, you're acquiring a patent portfolio, it may make sense to ensure that you are getting invention disclosure, getting copies of those. A lot of times for issued patents, it's kind of a secondary thought on whether, on getting those background materials and documentation, which led up to the actual initial filing of the application. And having those and making sure that you get those documents when you're due prior to the acquisition may come out to be very beneficial for you.
And going to that point of invention disclosure, that may be another separate little block you add in your company's invention disclosures, where you ask, is there any kind of possibility of expanding this? Where could you take this technology in any other space? Have the inventor this kind of question you're going to be asking anyway, right? How to expand this in terms of defensive office position in the patent context, but asking them at that point, or in good thing is you're going to get a written response on that, what they think at that point. So that's an inventive disclosure document that may be supplemented later on, but at least you have them start thinking downstream or writing down that, okay, other ablation technologies going to Minerva. Okay, covered that. We were already thinking other ways to do that. Okay.
So, hey, Keen, I have a question, if you don't
Yes,
mind.
sir.
Sure. So this is Josh Curry. So it occurs to me that what you're suggesting in terms of fixing this sounds like a good idea, but it sounds very expensive and time consuming. And, my impression as a litigator is that nobody spends that kind of time on an assignment, so could you speak to that a little bit? And then a sort of a second question, I like your strategy of having an unfiled claim, but, filing a really broad claim and then having to narrow to get it issued presents other problems during prosecution. So how do you deal with that?
So two things. Let's talk first question and then second question. First question going into, I think that's what V was kind of alluding to. You'd set up a kind of, I think, a pathway, invention disclosures, starting the conversation there. And then I think every time you file an application, you get an assignment on those claims. Okay. There may also be an internal thing where you look at, and this is a practitioner thing, where you said, okay, we filed with claims X. After the patent issued, they were Y, they were broader. Okay, you send another assignment to your for them to decide. So you just keep covering it up with assignments as you move forward on that. If it narrows, you don't care. If it's broad, and you do that, therefore you're covered with the inventor. Okay. Where it becomes more problematic and why you want to have pre-documentation on that is if in the course of prosecution, continuation, CIP, whatever you've done, the inventor's left and they're unwilling to sign an inventor, another assignment on potentially broadening technology. That's where it behooves you to have that beforehand. Now that goes to your second point. Okay, instead of filing, certainly I've always filed a very, very broad claim, omnibus kind of claim when I file a provisional. But alternative to that, I think there's a very good practice to have a document where you basically decide, here's X, here's the broadest way we could do this type of thing. And that is buttressed by an internal declaration. You just keep that document. So that's internal. That's not filed with USPTO, but that's internal to you actually talking about this overall. So I don't think it's as move forward, it's almost kind of, here's a modified thing. It's not as simple as it used to be, but it takes what we normally have been doing and just basically modernize it to the post-Minerva world. The assignments, having a document, this is covering X in a broad sense. Okay, boom, cover that in a broad context. You have background material that covers your broad context. That way you don't run into an issue where you filed a claim and then just cancel the claim because it's overly broad in that kind of context. So you're arguing into that aspect. So it's actually not an overtly expensive process for companies to do. However, it is something that, because of the kind of claim-focused aspect of the Supreme Court's ruling in Minerva, I think it's one that necessarily needs to be done. Certainly, it's going to create valuation problems for patent portfolios if you can't answer these questions as we move forward. Okay, some of the things we talked about, you can have contractual limitations that put in that they can't do that. Maybe they can only challenge it under certain terms of condition. You can challenge it in IPR as a litigation, those kind of things. So I provided some examples here. The other thing is you put them on a hook for costs. Okay, the interesting part about that is if they're went to another company and they're competing against you or whatnot, they're not worrying about these costs. going to be covered by that company or whatnot. But it's a way of a kind of asserting it's like it's not a loser pay, but it's almost a challenger play kind of provision in there. Okay. That last bullet on this page is one of the things we were talking about. Hey, additional close declaration that acknowledges your review of claims, optional claims or amended claims, ensuring those are executed by the inventor. Okay. Typically on those confirmatory type things, that's the one you want to actually buttress with that supplemental insurance. Every time they're filing another assignment, you're getting like the $50 or $100, whatever it is that you set up as a company for those awards. Okay. Obviously, on an alternate kind of outside view of our typical IP kind of perspective, we'd also want to look at this kind of assignee kind of context or non-compete kind of context, if that's available to you. Again, that's an employment law kind of consideration that's separate to that. But certainly, like a person in the Minerva case who's fundamental to the success of the company, whose technology is kind of core of the company, that's somebody you probably want to have in a non-compete in some kind of aspect. Because it's not just some engineer per se. It is really somebody who's very particular and very well-knowledged. That's somebody you want to actually potentially have that kind of employment law non-compete provision as appropriate and assigned and executed. So that's on the side of what we're doing. Okay. What you do, these quick claims, all these kind of things are in some of the terms that could be in these kind of master service agreements. So elucidating that it's not going to be obligated to, but obligated to assign particular inventions that they're, so if you're in a technology, you've been hired to invent here, anything that comes in here, you're going to do that. So instead of these generalized provisions, being a little more specific, having a little more specificity associated with those when in the employment, in generalized employment service agreements. Okay. And we're already starting to modify for clients their generalized employment things for this to try to address some of these issues. One, so they know when they're hiring and what's going to happen on that, especially if the companies have also started doing some kind of, as V had mentioned, hey, you made an invention, we're going to give you X on the dollars in support of that for each invention. Okay. Signees themselves, these are some of the things you might get pushback from them. I don't want to do these things. How do I do that on there? But that's what they're trying. That's what we're also looking at here in that kind of context. Okay. Typically, you're not going to get much of these kind of pushbacks on here, but or you can throw this out. How many people in this group have gotten pushback from assignees on scope of an assignment? I know my answer is 0 on it. You may get that later on as this evolves in the kind of an understanding of where they're going on it, but I don't think you're going to see as much on there for the, excuse me, I was referring to assigners on it, but I put out some of the things you may start getting back on that. The bottom bullet is probably the most important, that they're looking for some kind of additional consideration based on their assignment. Usually it's not these kind of context. It's more the firms that basically along the step, it's like, here's $50 for this, $100 for this, patent issues, it's whatever it is the company has to do here. And I can appreciate this is also somewhat of an onus for in-house counsel, because now a patent becomes even much more of a cost issue, right? You're trying to sell, we need a patent. Well, it costs money, and it's costing us more now, and they're resistant to that. But again, especially for companies that have the potential for selling patents, maybe they're an M&A target or setting themselves up on, these things are much more important that you do this right, so you cover it up. Okay. So bottom line is you've got tons of slides here I try to provide you many more options on that. As you can see, there's a on there. But bottom line is Minerva it's become a little more problematic. It's, as Robert mentioned in his question in here, it's some of our traditional thinking here has to shift. You're not assigning quote unquote technology that's in there, but you're actually assigning technology as defined by the scope of the claims that are being filed for that. So knowing that in your mind, start thinking in your head, how do I capture things as we move forward, especially with the context if I'm potentially getting broader claims as it matures, or if an acquiring company is going to mature this, would they be pursuing broadening claims? Okay.
One thing, if I can add, just so we've been talking really kind of like on the front end, right? Before there's an issue and before Assignor Estoppel actually gets brought up. Just a couple thoughts I had on if you find yourself in the position where Assignor Estoppel is being asserted, that the number one thing that came to my mind is the Privity Requirement. And if you have an inventor who's left the company, has joined a competitor, and you're suing them, and now they're asserting Assignor Estoppel through their inventor, then it does raise a privity question, and it does raise a question regarding whether there's a trade secret misappropriation that was done. Because now you can, there is an opportunity, not that it's always going to happen, but there's an opportunity that you can show some sort of nexus between what the inventor took with him and what he could actually be able to take with him, which is just the know-how. Another thing to consider is when you're drafting broad claims, you'll many times, I think you'll have multiple inventors. So when you have multiple inventors, and maybe one of them is the one who's gone over to the party that's asserting Assignor Estoppel, may want to look into whether the other, if you have any remaining inventors that are still at your company who can help respond to any sort of claims that, or any, I don't want to say claims, but any sort of arguments by them stating that, this is not what they invented. You can point back to some of your inventors who say, no, thermal imaging, the thermal ablations was something that we did consider, and was in my mind when we thought about this, that does help make it a kind of an issue of fact. And another thing to consider is if you ever have this argument brought up, are there dependent claims that you can fall back on, which show that even if with invalidity, patents still won't fail because there are dependent claims that the inventor did envision that were covered. So some additional things to think about if you're caught in the unfortunate situation.
It's so Brave New World posts this. The interesting, one of the rationales for having this kind of discussion today is I don't think this was on, or it certainly wasn't on the event horizon of many of the practitioners that I deal with. Certainly the companies I deal with are like, what does this mean to me? Type thing. So it's issues to be thinking about if you're in-house counsel going, where are we, how are we positioned? What do we need to do internally to actually meet this challenge? Or if you're quote unquote out-house counsel, you would advise your clients that there's potential issues here. Here's some simple ways that we can ameliorate these risks as we move forward in this kind of post whatever context. So I think part of it is just being aware that this is an issue. You're already starting to step up the bar a little bit, being aware of it, because that means you're going to actually make actions to address some of the problems here associated with it. We're rapidly ding. I think we're at 1. I imagine people's lunch bells are going off. But if there are any questions, please don't hesitate. Anybody got anything they want to ask? Or alternatively, feel free to reach out to V or I or to anyone on the staff, Josh and Lane, etc. Questions? We're going to give you to a count of about 10, and I'm going to do just like I do my students and say, okay, you're pumpkins and you're done. So.
Okay.
Oh, everyone's tired. Okay.
Well, if you do have follow-ups, I'm sure that Keen or Savash would be happy to answer them. And thank you, gentlemen, for the presentation. I think that, as you could hear from some of the questions, this was something that a lot of folks may not have known the details of. So we appreciate you bringing that out to us. Thank you very much. And that'll conclude today's CLE. Thank you for coming.
Thank you.
Thanks, guys. Take care.
Bye-bye.
This concludes today's meeting. Thank you for
Thanks,
joining.
Steve.
Good afternoon.